Good morning. Thank you so much for joining today's webinar, which I refer to as the Practical Guide to Serious Accident Punishment Act. Before we begin, I want to thank our friends from Kim and Chang for partnering with us on this webinar. Today, we are discussing a very important topic that will affect many companies located in Korea. SAPA is a new legislation that has just been enacted on January 27th of this year. It holds executives, like many of you here in the room, responsible for any industrial accident that occurs to your workforce. This is a significant expansion of the criminal liability for CEOs. As a lot of you know, one of AMCHAM's key initiatives is to make Korea a regional headquarters in Asia. To accomplish that vision, it's so critical that Korea create a business environment that's amenable to effective business risk management and growth. In fact, AmCham hosted a meeting with presidential candidate An Cheol-soo earlier this week. In our meeting, we discussed with Mr. An about this legislation and how Korea could ensure workplace safety without raising the risk profile of operating a business here in Korea. Today's timely webinar will help all of us understand this new legislation and how to mitigate any potential risks stemming from this new regulation. For today's webinar, we have an outstanding panel of speakers from Kim and Chang. First is Sung-min Won, a foreign attorney. We also have Kyson Keebong Paek, another foreign attorney, and Jae Kim, another foreign attorney. Sung-min is a member of Kim and Chang's labor and employment as well as SAPA practice groups and has an extensive experience in managing all aspects of legal and business affairs for some of the largest companies. Keyson's practice focuses on criminal defense, corporate compliance, and cross-border litigations. He is also a member of Kim and Chang's SAPA practice and represented a number of entities and individuals before a variety of investigations with authorities in Korea. And Jay specializes in litigation and crisis management involving both civil and criminal matters. His main area of focus are intellectual property, product liability, compliance, and government regulations. You know, today we have nearly 200 people joining this webinar today. This just shows you that there's a strong interest in learning about the latest update on this legislation and how all of us could stay ahead of the curve in mitigating these potential risks. I am certain that today's session will serve as a unique opportunity for gaining valuable insights and practical guidance on how to best navigate SAPA. AmCham will continue to strive to promote trade between Korea and the US. And by learning SAPA, this is another way in which we want to add value to our AmCham member companies. So without further ado, now let me hand it over to Sung-min, who will help lead this very important webinar. Thank you, and have a great day.
So thank you very much, Chairman Kim, for the introduction. Hello, everyone, and good morning. This is our second time getting together to talk about SAPA. We had our initial webinar almost a year ago, a little less than a year, I should say, in 2021, when the law was just enacted. Now, since then, there's been a lot of developments. And last October, we finally got a set of enforcement decree that actually gave us a little more insight into what we need to do. Now, for today's webinar, we wanted to, instead of just going through the law again and giving you the details we need to do to comply with SAPA, Serious Accident Punishment Act, we wanted to give you a little more practical perspective on how to manage and handle investigation and how to really mitigate risk. And before getting to our main topic, we thought it'd be, I felt it would be useful to at least sort of refresh our memories on what SAPA is, what we need to do. And I'll just walk you through what you may already be very familiar with, but just wanted to highlight some key concepts under SAPA. So with that, let me, sorry about the slide. So as you know, SAPA went into effect January 27, 2022 for companies with at least 50 employees. It's been in effect for less than a month. So there's a lot of questions and interest now in terms of how the law enforcement authorities will pursue violations of SAPA. Now, we know that SAPA, Serious Accident Punishment Act, imposes criminal punishment on businesses as well as their top senior management, whom we call responsible management personnel. If they fail to uphold their duties, carry out their duties under the SAPA to ensure safety and health of their employees as well as workers. And what SAPA is really, it reflects the concern of the public to really provide a safety net for our workers and to really emphasize health and safety in organizations where it was thought that a lot of the companies in Korea were outsourcing the risk to third parties, and they wanted to put an end to that. And we've witnessed a lot of public accidents, unfortunate public accidents. And basically the legislative, when you look at the legislative intent, the legislature really wanted to put an end to this by holding accountable the most senior person can really make a difference in the organization. So as I mentioned, January 27th, 2022, law came into effect. But for businesses with less than 50 employees, there's still yet two additional years of grace period. So it'll come into effect in 2024, January 27th. Now, I talked about the most senior person being potentially held liable under SAPA. We call this person responsible management personnel. And as I mentioned, it's basically the top decision maker. It's basically top decision maker who has authority and responsibility to externally represent the business and internally, generally and comprehensively manage the business. And in Korea, this person is basically the representative director or the CEO or 사장, 대표이사. In the alternative, the law also provides RMP can be someone who is in charge of safety and health matters. Now, it's important to note that the level of authority and responsibility over safety and health matters needs to be comparable to that of the top decision maker. So the expectation is this person, if the person is chief security officer, someone who's in charge of overseeing safety and health matters, that person needs to have the final authority in terms of budgeting and personnel management to ensure safety and health of the organization. If you recall, SAPA deals with serious industrial accidents as well as serious public accidents. And for purposes of today's discussion, we will again concentrate more on the serious industrial accidents. Now, what then is a serious accident? SAPA defines serious industrial accident as having one or more fatality, or two or more persons getting injured from the same accident, which requires 6 months or longer of medical treatment or hospitalization, and occupational illness affecting 3 or more people within a given year, exposure to same occupational hazard. In terms of liability, interestingly, SAPA, there's a minimum sort of imprisonment requirement for RMPs and business owners if they're found in violation of SAPA. This is triggered when there's actually fatality. And in addition to that, there's also a criminal fine up to 1 billion Korean won. If there's no fatality, then either business and the RMP will be subject to liability in terms of imprisonment of up to 7 years or criminal fine of up to 100 million Korean won. And this slides basically illustrates the point. Now, I just wanted to make sure that those of you thinking, well, you know, if there's the minimum sort of level of liability here in terms of imprisonment, are we talking about strict liability? So if there's any accident, will I be held liable under SAPA? That is not the case. There's no strict liability under SAPA. The law enforcement authorities need to prove causation. And so the slide sort of illustrates that point. There's a alleged violation of obligation under SAPA, which causes a serious accident and that affects a worker. Then, based on whether there's fatality or no fatality, one may be subject to at least 1 year of imprisonment or fine of 1 billion Korean won. Now, what are RMPs, responsible management personnel's obligation under SAPA? There are 4 main obligations provided under the SAPA. One is to establish safety and health management system, including the necessary personnel budget, inspection, and actually take measures to implement the system. The second one is if there's an accident, we need to have a plan to prevent recurrence. Makes sense. And number 3 is to adopt appropriate measures to improve the safety and health management system in the event the business has been issued a corrective order by governmental entity. Number 4 is take managerial measures necessary for the performance of obligations under the safety and health laws. Now, just wanted to further define what 1 and 4 obligations are. In fact, the enforcement decree, which was enacted last October, goes into a little more detail, gives us more insight about what it actually means to establish a health and safety system and what it means to take managerial measures. So what do we mean by establishing health and safety system? Basically, there's actually about 9 obligations that's defined under the enforcement decree. And in case of serious accidents, industrial accident, RMP has to establish dedicated environmental health and safety organization. Now, this only applies if the organization has 500 or more employees. They have to set up management goals, establish work protocol, and also need to obtain views of the workers. Also, prepare crisis management procedure and prepare appropriate EHS budget. Also, when selecting or outsourcing vendors, they need to be able to manage qualified subcontractors and have a means of selecting those who are qualified to provide services. And also, RMP needs to assign appropriate EHS personnel and provide adequate time, ample time for them to actually perform their duties, and also periodically check for compliance. These relate to establishment of health and safety management system and implementation thereof. Now, with respect to taking managerial measures necessary for the performance, it's basically taking measures to comply with applicable safety laws. And there's actually 3 main obligations under this requirement. One is to check compliance with safety and health laws. Obviously, in addition to OSHA, there's going to be, depending on the industry and the business you're in, there'll be other applicable laws, safety laws that apply to your business. So we need to check compliance with safety and laws and receive report at least once every 6 months. Also, conduct safety and health training as per the applicable laws, and take measures by securing budget and safety for the training. Also, if there's not inadequate training being conducted, then we need to take action, take remedial action to ensure compliance, and actually to provide support in terms of personnel and budget to carry out the training. Now, as I mentioned, SAPA sort of expands the scope of liability, and OSHA to a certain extent does cover third-party workers, but mainly the law covers safety, health and safety laws covers your own employees, workers at your premises. But SAPA actually goes one step beyond that, and basically, if business, if you're engaged in subcontracting or receiving service, or delegating, then you need to be mindful of third-party workers, eventually who may ultimately, you may be held liable if there's an accident. And this applies if the business is actually responsible for exercising actual control, operation and management over the facilities and equipment or the location. So we need to be mindful of the fact that not only are you responsible for your own employees, but also the employees of others as well. So what can we do to ensure compliance with ZAPA? Since the enactment, a lot of the companies have been preparing and really overhauling their system, safety management system, checking to see whether there are any gaps, whether they are in compliance with the requirements under SAPA. Now what you should be doing is really going back and checking to see whether actual practice is in line with your system that complies with the requirements under OSHA, other safety laws, as well as SAPA. So the 5 things that I just wanted to flag, point out is risk assessment, conduct risk assessment, specifically for the work sites and taking account attributes of your business. And if you find any gaps or opportunities, improve on the system. Make sure you actually take remedial action. And also establish a monitoring system to constantly check to see what opportunities you have, what gaps you have with in terms of complying with safety laws as well as SAPA, and establish evaluate using a KPI to review full performance, and having a standardized with measurable indicators to see whether everyone's performing their duties. And also, training is important. Continue to provide training. This means securing actual budget and time and resources for to train your people, and make sure that you follow up on the actual training, see whether people are in fact receiving training, adequate training. And also, it's really about managing corporate culture. So we need to have send a strong message from the top that safety matters, and everyone needs to contribute and participate in keeping themselves as well as their colleagues and the whole organization safe. So it's building a corporate culture to comply with not only your internal policies, but outside external laws that relate to safety. And also one may think about potentially reflecting the safety health KPIs in performance rating so that employees, the workers are actually following and constantly being reminded that safety is a very important aspect of their work and business. With that, I think we're ready to move on to our main topic, which is responding and handling investigations. Kyle, Attorney Paek, will provide you with some overview and some insight as to how an investigation process work, and from a procedural aspect, what we need to, how to prepare for these types of investigations, and what we need to do to mitigate such risk. So with that, Kyle, I hand it over to you.
Okay, Sungmin, thank you for the brief introduction about this new law, SAPA, yeah, Serious Accident Punishment Act. So actually in this chapter, I will explain briefly how the investigation is expected or is being conducted. The investigation is conducted in the SAPA related cases. There have been several cases, involving the serious industrial and the worksite accidents since the SAPA took into effect late last month. But although the cases are not many, I found some interesting or the unique and different aspects on the investigation against the SAPA related cases in comparison with the previous investigation pattern. So I will talk about those issues, particularly based on some cases like you remember some serious accidents were reported recently. For example, a landslide accident, which happened in the quarry site. And another one is that the elevator accident. So the elevator fell down in the new building construction site. So based on the news reports, I found something and then we explain to you how the investigation on the SAPA case will be conducted. But before I touch upon those issues, let me just briefly give you a comparative analysis between the OSHA case, the investigation on the OSHA case and the SAPA case. So on the left-hand side of this slide, you can find the investigation pattern and approach under the OSHA Occupational Safety and Health Act regime. So you can find the site managers and then EH managers. These persons were the target of the investigation under the OSHA in the past regime. So it was a usual practice that the site manager and EHS managers were punished by way of the SAPA, the OSHA application. And this OSHA application was not expanded to the business management level, such as CEO or CSO, the high level of the company, because usually the top level decision makers, the CEOs, they were not deeply involved in the on-site management of the safety and health matters in the field office. So it was difficult for the authorities, investigative authorities, to prove and to think that the high-level management level should be punished for the culpability on this OSHA regime. And that is one of the most important reasons why the SAPA was enacted. And then now under the SAPA regime, this law targets, the target of this law is the responsible management personnel, the RMP, and then that can be the CEO or CSO, the top decision makers, at least on the matters of safety and health. So on the right-hand side, you can find the business level, high level decision makers will be the target of the SAPA. And based on this understanding of the comparison between the OSHA and ZAPA, let me move on to the investigation pattern, which is shown on the recent case investigation. On this slide, you can find the two agencies, the police, and then MOEL, Ministry of Employment and Labor, so Labor Ministry. And then the police is in charge of investigation based on the Criminal Code, Article 268 of Criminal Code stipulates the punishment on the manslaughter due to the occupational negligence. So the police has the power and has the power, investigation power, to investigate on the allegations in violation of the Criminal Code Article 268. This is the same, even at this SAPA regime. But on the other hand, the Labor Ministry, actually the Labor Office, had the authority to investigate, as I explained earlier, the site manager and the EHS managers based on the OSHA, on the allegation of the OSHA violation. And in addition to that, that means that Labor Office will investigate OSHA violation even under SAPA regime, but on top of that, the Labor Office were given another additional power to investigate on the allegation of the SAPA. And this authority to investigate on the SAPA allegation, SAPA violation allegation, is exclusively given to the Labor Office. So the pattern, the police will investigate on the one side the criminal code violation, and then Labor Office will investigate the other side, SAPA and the OSHA violation. They have conducted investigation in parallel. But in the past, still they investigated respectively, but details of the investigation were overlapped. So in case for example, the arrest warrant or the search and seizure warrant should be obtained, for this kind of compulsory measures, usually the police led the investigation against the case, the allegation, and actually the underlying facts are similar. So the police, for example, asked the search and seizure warrant on the field site, and they analyzed the material seized by this warrant. And the outcome of the search and seizure were shared with the Labor Office. That was the usual pattern in the past under OSHA regime. But now it is notable that based on the news reports on the two cases, two outstanding cases, Labor Office leading the investigation. So you can find that the Labor Office raided the search and seized the offices of the companies. That means that the SAPA is attracting the public attention, and SAPA is really critical on the investigation against this accident. So as I explained, on top of the criminal code violation and OSHA violation, but the most critical point is how to apply the SAPA and how to prove the SAPA violation. And based on this background, we can understand why the Labor Office is leading the investigation. The Labor Office is asking the search and seizure warrant for this one. And also, in the past, the police searched and seized, and because they had more knowledge and they had more expertise and then forensic capacity to do the search and seizure. But now the Labor Office is enforcing their capacity for forensic review, which is necessary for search and seizure. But on the other hand, this is fully supported by the prosecutor's office. So it seems that prosecutor's office is reviewing the cases, and they are supporting the Labor Office's search and seizure. So there is more close cooperation or the supervision by the PO, prosecutor's office, and the Labor Office. So this is a very notable difference from between the past investigation than recent investigation. So, and then let me just talk more about the search and seizure. So based on the news reports, I found that just immediately after the accident happened, there was a downrate, there was a search and seizure on the field site, the work site of the company. And it is beyond doubt that the authorities, the labor office, the police wants to collect and secure as many evidences as possible so that they can figure out what kind of safety measures were neglected and what kind of violation of OSHA or what kind of violation of the criminal code article 268 were committed on the worksite level. And I assume that their investigation, their interview with the persons on the sites are conducted in parallel with the analysis of the material seized by search and seizure. And the next steps will be, they will investigate on the head office, right? And then coincidentally, I found in the news reports this morning that there was a search and seizure on the head office of the company, which means that based on the analysis of the material seized on the work site, and then based on the outcome of the interview with the on-site people, the employees and then witnesses, they are now targeting the head office. Definitely, in addition to apply the SAPA. So they will try to find out whether the company, particularly the head office, especially the RMP and then the dedicated EHS and the safety and health unit, they actually they established a safety and health management system, and whether they set in motion this safety management system and appropriately. So they will try to find out that there must be some negligence, that there must be some misconduct, or there must be some hole or lack of the full the implementation of the obligation, which is specified in the SAPA. And there seems to be the current status of investigation on which I can find that there was some interesting difference from the previous investigation pattern. Sungmin, any?
So Kyle, so thank you very much. That was very helpful to understand, and thank you for giving us that overview of investigation, investigative process, procedure, and the parties involved. You know, that I think search and seizure, dawn raid, it's very stressful. But having gone through a couple of these, actually experiencing search and seizure, you know, there's no surprise so long as you're prepared and understand what to expect. I think that's important. I had some questions about, you know, we have the OSHA, we have SAPA, you mentioned criminal code violation, and you know, we have different parties now, authorities in terms of investigation. MOEL has that, and we talk about the police and the role the PO prosecutor's office plays. Now, so who is leading the investigation, and what is the role of the police?
Yeah, there shouldn't be any misunderstanding that I mentioned the labor office. It seems that the labor office is leading this investigation, particularly in terms of the SAPA application. But that does not necessarily mean that the police is passive on this investigation. The police is also paying great attention to this accident. So, and based on their original power to investigate on the criminal code violation, they actively participating in the search and seizure and then the analysis of the material seized. So it seems that the police is cooperating closely with the labor office, more closely than the previous regime, that they are cooperating with the labor office and they are analyzing based on their great knowledge and experience and expertise. And also, we have to take note that although the SAPA is exclusively in charge of labor office, but that does not mean that the police cannot investigate against the high-level people, top decision makers, such as RMP. CEO,
So-
CSO, because they can apply the criminal code even on the RMP. That means that the RMP will be the target of the investigation by the labor office in terms of the SAPA violation, but also the police, after the enactment of the SAPA, it is my, I guess, an expectation that the police will also try to expand the investigation into the top level and the high level, the top decision maker of the company. Because in the previous SAPA, OSHA regime, usually the police, the target of the police investigation on the criminal code was also limited to the on-site people, site managers and then each managers. But now, by taking note of the SAPA, the police will definitely try to go after the RMP, not by SAPA, but by the criminal code. And that is my expectation.
Right. Thank you for that explanation. Then what about the public prosecutor? Are they playing any role? You did mention that they
Sorry
work
to
closely with.
interrupt, but I think we're getting some really interesting questions in from the audience. So
Okay.
maybe we should
All
take
right.
those. After we take the question, if we have any time left, I can run through the last section about risk management. The first question I see is that, and they're really good questions, actually. Business owner, who is that in the case of a MNC? Maybe you can talk about that a bit. In my 2 cents is that this is always going to be the default. The default is always going to be the registered representative director, the CEO, country manager, whatever you want to call it. And that's what SAPA is actually intending to target and make the engine by which this law operates. And the term business owner, that's kind of uniquely Korean, right? So the law is drafted with Korean companies in mind, but it's also going to apply to multinationals. So I think this is a really good question.
Right. So thank you for that, Jay. We're talking, in terms of business owner, sole proprietor, whoever owns the business makes sense. So if you own the business, you're running the business, then you should be held liable under SAPA. With respect to responsible management personnel, in terms of company, there's no owner per se. So in Korea, that person represents the business. And therefore it's 대표이사, representative director. But for MNCs, mostly these people may be the country manager, the GM, or managing director. So what are the questions?
This is a good one. For the penalties, why does imprisonment have a minimum limit, but fines have a maximum limit? I think probably because you can't have, infinite fines, probably subject to a constitutional challenge.
Well, I can give an answer.
Well, yeah, Kyle can give you an answer. Right?
Okay,
There is a maximum sentence, but
yeah.
Kyle, can you give us a little insight on that? Yep.
Yeah, actually, I'm a Korean lawyer, Korean attorney, not the foreign attorney. So this is definitely my
Ex-prosecutor as well.
Yes. Right. So it's an interesting question, but first of all, you have to understand the criminal code. The criminal code has a very general and fundamental provisions, and those provisions will apply to the other specific penalty provisions of the law, such as SAPA, OSHA. And in this criminal code stipulates that there is a limit. There is a maximum of the imprisonment. The maximum imprisonment is 30 years. So when you combine this one, the maximum imprisonment is 30 years in the criminal code, and the minimum is 1 year in the SAPA. And when you combine it, you can figure out that the imprisonment range is between 1 year and 30 years. On the other hand, this criminal code has a minimum of 50,000 Korean won, right? And the SAPA has the maximum of the 100 million Korean won. So when you combine this one, you can find the range of fine. So it is from the 50,000 Korean won to the 100 million Korean won.
Okay, so I think the peculiarities of the Korean legal system. So the next question, this is a really good one too. A lot of good questions here. Do we expect a difference in the way the penalties are applied between Korean nationals and foreign nationals? There shouldn't be, right? There shouldn't be.
Absolutely. There shouldn't be any discrimination in terms of how they apply the law. That is the expectation, and my understanding is that's the practice. There are a couple of questions that I think Kyle can also give us provide some explanation. One is, I think we briefly mentioned this. I briefly mentioned this. Who needs to prove causation? Okay, when there's an accident, investigating authorities come in. Who has the burden of proof? And also, is this more strict liability? What if I did everything that I could, but despite all that, there was an accident? Am I going to be punished for that?
Let me respond to that. But before I respond, I will correct my mistake that the maximum fine of the SAPA is not 100, is 1 billion Korean won. And the proof, the burden of proof, definitely about the causation and the violation of obligation is on the shoulder of the prosecutor's office. Before, I mean, the labor office and the police, these investigation officers will try to find out that evidence to prove that there was a violation of the obligation and there is a causal relationship, real causal relationship between the violation of the obligation and the real accident. And those causal relationships should be established by the prosecutor's office. That is the legal principle. However, I mean, in reality, the company should be prepared to get a lot of questions and a lot of RFI on those issues, right? And whether they fulfilled and they exercised, they did their implementation to the full extent. And there isn't any causal relationship between for example, minor violation of the SAPA obligation and then the real accident. So probably the arguments by the prosecutor's office and the company's counter arguments should compete against each other. That can be the real situation when the accident happened and when the investigation occurs.
Thank you for that. Jay, I really want to get to your presentation. I think it's important that we do talk about some mitigation strategy and what have you. But before we get there, if we can entertain one more question. There's one question about if there's any conflict between SAPA and OSHA, which takes precedence. Jay, can you answer this? Or my understanding is, OSHA provides it's basically Occupation Safety and Health related act and has over 670.
They impose their own
sets of requirements
and penalties, so they're just going to work together.
Yes, yeah. So
if I turn to the original question about whether foreign country managers are going to be treated differently from Koreans, I think again it's no by design, but in practice, I think there is an element of if it's a really serious accident, a foreign CEO can receive a greater amount of scrutiny. I think a large part of that is depending on what type of media attention, social attention there is on the accident. And the angle that I would be concerned about is the multinational somehow not doing its part to maintain safety standards at the Korean site. So that's an additional aspect of the scrutiny or investigation and reputation management that a foreign GM might have to deal with that a Korean company would not have to deal with. So I think it's more in that aspect that you might see a difference in what happens, how things play out.
Right. So with that, Jay, do you mind?
Sure. So
covering risk management
risk
strategy?
management. What happens if there is an actual accident, and we don't want that to happen, of course, and we do everything possible so that doesn't happen, but it does happen. And real life situations we have to be prepared to deal with. So this is what this section of our presentation is attempting to address. And in my mind, conceptually, there's things that you can do before the accident and things that you can do after the accident. And the more you do before, the more it helps after. So on the left side are the things that we can look to do before the accident. And of course, this has two aspects, right? One is we do actually want to minimize and prevent accidents as much as possible. So all of this stuff, the training, the having the management system, inspection system, culture, all that helps that, you know, I would say the more important goal of actually preventing accidents from happening. But if you do that, all that also works to your advantage once in the unfortunate event of an accident, because all that is evidence in your favor to show your SAPA compliance. And, you know, on an ancillary note, your OSHA compliance as well. All that works together. And once there is an accident, you need a clear response plan. And all that means is that to minimize the chaos, to minimize the confusion, once there is an accident, if people know who to contact, what to do, it helps deal with that accident. And being aware that there's going to be investigations. So to be both legally and psychologically prepared for that process is what we're talking about here, before and after the accident. And the clear designation of the RMP, you know, I get questions from clients saying, okay, if we call somebody the RMP, is that enough? The short answer is no, right? Because the law says the RMP has these obligations and it has these characteristics. So the features or I would say the authority that's designated by SAPA, the RMP actually has to have. But if you don't designate the RMP, you have all these downsides, right? If you don't have, according to your organizational structure, and it can be the GM, if that's what you choose to make it, or somebody else, and if you imbue them with that authority, or as close as possible as contemplated by the statute, it helps to minimize the scope of the investigation, right? And otherwise, they could be looking at people, all the executives in Korea and even people outside of Korea potentially. So there's even exposure outside of Korea, theoretically and potentially, without a clear organizational structure that tells the investigator, okay, this is the person that is potentially subject to a SAPA violation. And of course, this is the way SAPA is designed. It's the way it's designed to work, right? To place all this burden on that RMP to fulfill all these statutory obligations. And the logic is that that will help to uplift the safety and health practices of the company. And that clear identification or designation is what the law is asking for. So having this will help the company deal with the investigations that ensue after an accident. So the accident happens. When you're responding, one aspect is that just be prepared that there's going to be multiple agencies involved: the police, the prosecutor's office after a certain stage, the labor office, and depending on the type of accident, it can be the environmental agency, fire department, and so forth. So there can be a lot of streams involved in the investigation. Doesn't necessarily mean that you have to do anything different at your end, but being aware of that and being prepared to respond to that. And because of these multiple streams, what's really important in our experience is that there's a clear designation of a team within the company working with outside consultants or law firms, PR firms, and so forth, to help deal with the many different strands of things that could be going on. And of course, this is also essential in terms of not only dealing with the investigation, but other stakeholders as well. The victim's family, for example, the media, the ability to conduct a rigorous, robust root cause analysis. So you know what you have to say in response to the questions that you'll face during the investigation. And as part of this also, we can consider certain remedial or mitigation measures to look at reducing any penalties that might ensue. And this would include things like looking at a settlement option with the family, if that seems like the appropriate thing to do. Also, very important for us to show the government, the investigative agencies, that the company is doing the right thing. And this includes things like submitting as quickly as possible measures to remediate, fix anything that was wrong, basically, and to prevent any such issues going forward. And that's required under a lot of OSHA laws anyway. So it's part of that compliance aspect as well. A quick rundown of things that you might look for, you should consider as part of responding to an accident, right? So preserving all the evidence, that's a key aspect, because later on, if you're considered to be missing certain documentation, or God forbid, to have gotten rid of some documentation, that can actually operate as an aggravating factor in the investigation, right? You don't want to be accused of hiding evidence or destroying evidence in addition to OSHA or SAPA violations that you might be charged with. So this type of preservation and getting the company departments involved to make sure that happens, that's an important part. Also making the reports that are required under the laws, and this would be OSHA. There's various reporting requirements that apply depending on your industry, the type of accident, and so forth. So making sure all that happens is an important part of the response effort. We talked about having that control tower in place. And then actually dealing with the investigation, the first step is for the company to understand what happened, right? So identifying what the actual facts are and the root cause of the accident is critical, because that gives us and the company the right information to formulate a response strategy or to deal with the government investigations. And another part of the checklist is making sure that you have the right communication strategy in place, right? Something that is sensitive to the circumstances and appropriate in light of things like the level of attention the issue is getting, the level of media attention, NGOs, victim groups, and so forth. All this can be part of or needs to be considered as part of the communication strategy.
Labor union as well.
Sure. And the level of cooperation with authorities, that's another important aspect of the response strategy. So in essence, showing everybody that the company is doing the right thing. And if the perception is that, it helps a lot, tremendously, with every part of that investigative process. So I wouldn't say, trying to get brownie points, because this is part of actually doing the right thing, right? I mean, showing the everybody involved, police, labor office, unions, that the company is being transparent as much as it can be and trying to do the right thing. All this is important. Also dealing with any work stoppage orders that might exist, and reputational risks, reputation management, that's another important aspect of the response, right? So here you might be looking for expertise outside the company as well to get some help. This is a very dense map. I'm going to leave it because it's a roadmap for dealing with an accident prior, and it's an attempt to bring together all the things that we talked about in the previous slides about where it fits in terms of the timeline of dealing with an accident response. So you can refer to this later. And in terms of the resources to address an accident and respond effectively, these are the types of resources that we think that the company should consider. Things like EHS expertise, criminal law expertise, of course, because that will be a big part of what makes up the ultimate outcome of the investigation and dealing with any penalties that are sought to be imposed against anyone. HR expertise, because of the, if it's an industrial accident, the union will become involved. Industry expertise, and as part of that, expertise with if there's technology or involved with what caused the accident and the remedial measures, that type of expertise will also be important. Product liability, any type of product or related, this is more on the public accident side, but if there's consumer harm involved, we can face civil liability for product liability. So that's another potential part of the resource that might be needed. Compliance, of course, dealing with government agencies and so forth, and outside experts as well. So a lot of functions. You may not need everything for each type of accident, but a lot of these elements we see turn out to be necessary at one point or another. So it's a good idea to make sure that these resources are at least available if needed. So that's the end of my section.
So thank you for that, Jay. We're almost out of time. It's almost 11 now. I know we weren't able to address all the questions, but please feel free to contact any one of us. You have our contact details, and we'd be happy to respond to any additional questions about SAPA. And just wanted to thank everyone for joining today, as well as AMCHAM and Chairman Kim for giving us this opportunity to speak to you again about SAPA. And with that, I wish you health and safety, and have a good day, and happy Friday.
Thanks, everyone.
Okay.
Appreciate it.
Bye-bye.